And counsel, your appearance, please.
Good morning, Your Honor. Excuse me, good afternoon. Christopher Shemke appearing on behalf of my client. This time makes sense the matter being heard via Zoom.
All right, thank you. And Mr. Curry, can you please state your name, please?
Tony Michael Curry Jr.
All right, and counsel, we ask to the arraignment.
As the arraignment, we wait for
This case starts like so many others, but quickly takes a turn that raises serious questions about responsibility, accountability, and the consequences of ignoring the system. A routine traffic stop uncovers something much bigger: an outstanding warrant, a missed court date, and a defendant claiming he had no idea any of this even existed. But here's the twist. The court isn't buying that explanation so easily. With a judge pressing hard for answers and a defendant struggling to keep his story straight, things escalate fast. The real question is, was this an honest mistake or a failure to take responsibility? Stay with us, because what happens next could cost him more than he expected.
formal reading. My client stands mute.
The court will waive the formal reading, enter the plea of not guilty for purposes of the arraignment, and then we will schedule this matter for pretrial on May 14th.
Second, he's like, that's it,
15.
Oh, the state of Michigan, I'm so sorry, May 15th.
8:40. Oh, sorry. At 9:40.
At 9:45 a.m. Counsel Esteban.
Yes, as the bond judge, I did speak with my client. He indicated that he was unaware that he had an outstanding case. He was pulled over and he was very cooperative with the police, but he is gainfully employed. He does landscaping. He resides in Brownstown. He has 3 kids, ages 2, 8, and 15. With respect to requesting any leniency when determining an appropriate bond, we would ask consideration for a personal bond in this matter. He does assure the court that he will not duplicate the error that he made by not getting this matter squared up in a timely fashion, but will absolutely appear at any and all future court dates. Thank you, Judge.
Okay, so sir, when did you move to Brownstown?
4.5 months ago.
Did you change your address with the Secretary of State?
No, I haven't got a chance to. Been so
Awesome.
busy working.
I think that's something they can actually just do online, so. And are you on bond in any other jurisdiction, sir?
I can't hardly hear you. It's too loud.
Are you out on bond in any other jurisdiction?
What you say?
Are you in a bond in any other jurisdiction? Do you have a bond through any other court?
No. I don't think so.
How long did you live at the home on Second Street in Ecorse?
What you say?
How long have you been living in Ecorse?
That was last year.
Okay, how long?
Moved there from last year. It was in Texas.
You were in Texas. When were you in Texas?
My wife is a truck driver, and I went on the road, over the road with her.
Okay, so when were you in Texas is my question, sir.
Say how long?
When were you in Texas? What year?
The end of last year.
Okay, so you were living in Ecorse when this notice was sent out to you, sir. But not only that, you had contact with the police department and you were arrested before you found it out, right?
Did you contact the police before you found out? That's all I can say.
When was that? I think it's probably the last.
Sir, let me say this. So let me say this. You were arrested and you had a blood draw for this matter. And you did not contact the court to find out when your court date was. So while your attorney has indicated that you didn't know that you had an outstanding warrant, that is on you, sir, to have contacted.
Right here is where things start to get interesting. The defense is clearly trying to humanize the defendant. Steady job, family responsibilities, 3 kids at home, all of which are classic factors courts consider when deciding bond. These details are meant to show stability and reduce the risk that the defendant will flee or miss future court dates. But here's the problem. All of that can be outweighed if the court believes the defendant has already failed to take responsibility once before. And that's exactly what's about to come into focus. The judge isn't just listening, she's analyzing whether this is someone who respects court obligations. So let me ask you, if someone claims they didn't know about a case, should that excuse missing court? Or does the responsibility still fall on them?
To the court to see when your court date was. Not only that, this court sent notice to you at your home on Second Street in Ecorse. And you didn't show up.
I ain't stayed in E-course since the beginning of last year.
Sir, we sent notice to you, I'll tell you the date we sent notice to you. We sent notice to you on December 12th of 23, while you were still in Ecorse, for your court date for January 2nd of 2024.
I wasn't in E-course that area. I was in Texas that time.
Sir?
So we left right
You
after.
chase people, sir, the court doesn't chase people around the country to find out where they're at. You had police contact, you were then arrested, so it was incumbent upon you to follow up, and you did not do that.
No, I didn't. You're right.
How is it that you're in custody today, sir?
Yeah, John, he was stopped. It was a vehicle stop, and they found that he had not a staying warrant, and they took him to custody.
Okay, and sir, you even posted a bond. The court's going, that now has been forfeited, the court's going to order a $5,000, 10% bond on account A. And, so was your client a passenger in the vehicle?
We didn't have a dialogue regarding the nature of where he was in the vehicle.
Sir, where in the vehicle were you when you were arrested today?
That's good.
Can you repeat that?
Sir, were you the driver of the vehicle today, or were you the passenger?
I was the driver.
Driver, even though you don't have a valid license.
What'd you say?
Your license isn't valid to drive.
Yes, it is.
Your license is valid? How long has your license been valid, sir?
For a while.
What?
I say for a while.
Well, I'm showing that it's suspended, but that could be an old, yeah, that's an old one. Okay. All right, the court's going to order based upon, Mr. Curry's previous failure to appear, the nature of the charges in this matter, the court's going to order a $5,000, 10% bond on count A. You're not in a $5,000 personal bond on count B, C, and D. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to operate a motor vehicle without a valid license. And then we'll see you back on the 15th. Thank you.
What you doing?
500.
In the end, the court's decision reflects a balance between giving the defendant another chance and holding him accountable for past actions. The judge imposes a $5,000 10% bond on the primary charge, signaling concern over his previous failure to appear, while allowing more lenient personal bonds on the remaining counts. At the same time, strict conditions are put in place: no driving without a valid license, no substance use, and a clear expectation that he follows the rules moving forward. This case is a strong reminder that in the eyes of the court, staying informed about your legal situation isn't optional. It's your responsibility. Missing that responsibility can come with serious consequences. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.